Right. Good evening, everyone. We are live, the Open Forum series, part two from a couple of weeks ago. Got a lot of feedback, positive feedback from everyone, and some proposed topics. And today we're going to talk about law enforcement's use of force, qualified immunity, liabilities, and some really fun stuff. I got some great experts with us today to talk about that. I wanted to broach the subject and bring up this issue because it's become so important after the deaths of George Floyd and other people that have other police officers that have been accused of using excessive force and the consequences that that's had in our nation. So I thought this would be a great opportunity for people to learn about what it is that a police officer goes through when he's faced with someone that may be resisting arrest or that is a danger to himself or to the community, and then talk about what the implications are in court, not just criminal liability, whether they're being charged with a crime, but also when they get sued, which happens. So I'm going to go ahead and get started with Albert Rodriguez, and he is an expert. I'll let him talk a little bit about himself. If this starts sounding like a deposition, my apologies. That's my nature, and I start asking questions as if we're in a depot. So, but please feel free to expand upon my questions. Don't feel that you have to just answer the question before you, because we are not in a deposition. So, Mr. Rodriguez, thank you very much for being here. If you could please introduce yourself, tell us a little bit of your background.
Yes, sir. I'm Albert Rodriguez. Actually, I'm from Five Forks, Texas originally. Attended Texas A&I University way back then. Then went to work for the Department of Public Safety. With the Department of Public Safety, I reached the rank of commander, the director of training. And I spent 33 and a half years with the Department of Public Safety. And now I do consulting work in the arena of law enforcement procedures.
Great, and that's why you're here. We also have with us two great attorneys, honored to call them friends of mine, but I've also seen their work, and I can say that they're outstanding lawyers. Let me begin with Heather Scott, who is a former colleague from my old firm. She's in Cameron County, and she's taken on a lot of these cases, a lot of use of force cases in her career. Heather, do you want to introduce yourself?
Sure. Good evening, everyone. Thank you, Judge Fonseca, for inviting me to participate with this panel. I know all these faces, they're very familiar, and I enjoy working with all of them, even if it's against them, Victor. So they're all very qualified to talk about this very important topic. So I'm, like Ismael said, like Judge Fonseca said, I'm a partner with Guerra and Sabo in their Cameron County office, but I do work all over the Valley in South Texas. In late August, I'll be practicing 16 years. I'm a graduate from Southern Methodist University School of Law. And I've been practicing these types of cases pretty much my entire legal career. So I have seen a lot of these types of cases, various aspects of use of force and police practices. I've worked with Albert Rodriguez on numerous cases. And right now, especially during these times where this has become an issue on the forefront of national news, I'm really glad that you're bringing it to the attention of the local community, because there's so many different aspects of this issue, not only from the training perspective, but also what happens once it gets into a court of law. So thank you for bringing this to the community's attention.
Thanks, Heather. And last but certainly not least, Victor Rodriguez, who I've known since I started my career when he was an AUSA here in McAllen, dealing with some civil cases, and then he was in defense practice, and now he's doing some plaintiff's work. So he's done it all, it seems, in the civil field. So Victor, if you could just give us a brief background.
Sure. Thank you, Judge, for having me on the panel. I echo the sentiments shared by Heather. It is an important topic, and I'm glad to be talking about it. Like you said, I've had varied experience. I've worked on both sides, defense and plaintiff. I currently have a solo practice. When I was working for the Department of Justice as an AUSA, I did defense work in excessive force claims against federal officers and federal agencies. And now, since I've gone out on my own, we've taken some plaintiffs' cases representing individuals in excessive force claims against municipalities and police officers. I wouldn't say that I'm an expert in the field. I'm learning. I've learned a lot from Heather, and so I thank Heather for that. But it is certainly a field that needs to be discussed at this time, and I'm glad to be here to do that.
Thanks. Yeah, I think you're being a little modest. You've been doing this for as long as I've been a lawyer. So let me bring in Albert first, and let's talk a little bit of the basics. What is use of force when you're talking about law enforcement? Because you hear the term excessive use of force. So let's start with the use of force.
Yes, sir. Basically, the most common force options that law enforcement officers have, obviously, is command presence, then verbal directions. Those are two non-physical force options. Then you move into the physical force options arena, right? And you move up into empty hand control, right? It's basically the utilization of officers' physical strength, whether it's joint manipulation, pressure points, anything that does not involve actually striking. So then you move up to the next level, and that's what we call stunning techniques. And that's when an officer uses their personal weapons to strike. And the whole objective of striking is to distract, to be able to accomplish a legitimate law enforcement objective. Then you move up to chemical irritants, and there's all sorts of pepper sprays, if you will, right? And then you move up to the impact weapons. In the impact weapons arena, you've got obviously the baton, and also to include in that particular classification also is the taser, the utilization of the taser. And then you move on to the use of deadly force. So anything that involves physical contact, if you will, in trying to attempt to control resistance is the actual use of force, right? If we escort somebody, if a police officer simply is escorting somebody without any resistance, that's not considered the use of physical force. It's anything designed to control physical resistance when we talk about force.
So then the term excessive force, what makes it excessive?
Again, it's anything that is unreasonable. Anything that is unreasonable. And by that, we mean is that when we say reasonable force, we talk about the force that a reasonable officer could use when presented with the same or similar circumstances. That's reasonable force. Unreasonable force is quite the opposite. That force that a reasonable officer would not utilize. That is what we call excessive force. That it goes beyond what is needed to control the situation.
So, but who gets to determine when it becomes excessive? I mean, what's reasonable to you may not be reasonable to me. Isn't that a logical question that you'd be asked?
Yeah, yes, sir. And a lot of agencies still use the use of force continuum. By that, I mean that the continuum basically says the subject does this, the officer responds with this. An example of that would be a subject aggressively attacks and punches a police officer, okay? A normal response to that, a reasonable response would be one level of force higher than what the officer is being presented with. And that would be the utilization of the baton, right? But that's utilizing the plain use of force continuum, right? Which to me, it needs to be altered just a little bit, because when we talk about the continuum, it only analyzes what the subject is doing and not the circumstances surrounding what that subject is doing. That is very critical. Like, for example, if you've got an 82-year-old lady coming at a police officer with a small knife, right? And she is within 18 feet. right? In most situations, okay, the reasonable force would be to back off, right? If that's possible, or to try to utilize some kind of control technique, such as a taser, right? Some kind of control technique. Whereas if it was a 250-pound male subject, appeared to be under the influence of intoxicating substances, right? And he's within 15 feet, the utilization of deadly force might be appropriate. So the circumstances have a lot to do, right, with how the officer responds. And the officer merely responds to what he's being presented with. So he's got to evaluate in fractions of a second. He's got to evaluate all these circumstances and make a split-second decision.
On a very important point, because all of this, he needs to make that determination right then and there, because if there's a threat to his safety or his life, he's going to have to decide whether or not I'm just going to back off from that 82-year-old woman, or I'm going to have to take out my gun.
Correct. And those decisions are made in fractions of a second. And that's why there's specific, pursuant to law enforcement training, there's specific case law that says that when you evaluate an officer's actions, you must consider that officers at times are required to make split-second decisions in tense, uncertain, and rapidly evolving circumstances. So when you evaluate an officer's actions, that's got to be taken into consideration. Now, what a lot of people see, Judge, is obviously and do is a lot of Monday morning quarterback, right? They go, well, he could have done this, he could have done this other, right? But that is in hindsight, right? The officer's got to operate with the information that he knows and perceives at the time and make those split-second decisions.
So how are officers trained to be able to make those decisions in fractions of a second?
In most situations now, what most law enforcement agencies are going towards is scenario-based training. Put them through scenarios, right? And you evaluate to see if they're making the appropriate decisions, using the appropriate judgment. Because, an officer's use of force is a discretionary law enforcement function. By that, I mean that there's no book or training instructor that can tell an officer, when you encounter situation 1, 2, 3, 4, you respond with A, B, C, D. There's no such thing because every situation is unique. There's no two situations that are alike. Us officers have to use their judgment and discretion, right? And that's why you try to provide them with as many scenarios as possible, put them through as many scenarios as possible, and you evaluate how they react.
Right, and that's where the critique of the use of force continuum comes in, right? Because it seems to be a bit myopic without looking at all the circumstances. I look back when I worked for the Justice Department Civil Rights Division, which was a division of an office in DC that prosecuted officers for excessive use of force on the criminal side. And you looked at this continuum and you looked at how an officer responded to the threat of the person. And you look at you go a step up without considering it's difficult when you're not considering the entire circumstances under which the officer was acting. So, and like I said, the Monday quarterbacking is certainly at play. And you bring up the discretion, which brings in Heather and Victor. That's where the legal issues start coming in, right, Heather?
Right. As Albert was saying, there's no handbook, there's no manual that would dictate every single scenario that an officer can possibly encounter during their career. So these scenario trainings are pretty much the best thing that can be offered to give them that experience and training to make that split-second determination. And that kind of goes into how their actions are evaluated from a legal standpoint. Once, if a person decides they want to file a lawsuit because they're alleging that the officer used excessive force, the legal standards that judge how the officer's conduct whether or not it was reasonable or whether or not it was excessive come into play. And as Albert was mentioning, case law and how it dictates, that's a lot of it. A lot of how we evaluate the officer's conduct is dictated of how previous courts have ruled on different types of scenarios. And officers are entitled to what's called qualified immunity, and they're entitled to assert that defense. Now, most people probably have never heard of qualified immunity until recently, with all the discussion of what's gone on, with the George Floyd incident, and we're hearing more and more dialogue and discussion of how officers are held accountable. So just the legal definition of qualified immunity goes back to the court. Supreme Court established it back in the 1980s. And it basically shields law enforcement officers, or really any government official. But in this case, since we're talking about police officers, it shields them from liability insofar as their conduct does not violate clearly established constitutional rights of which a reasonable person would have known. So that's the legal definition. Let's put that into layman's terms. So what courts do is they look at the circumstances of what happened in that incident and what the officer was facing at that very moment. Try to see if at that time, did the officer have the reasonable belief to believe what he was doing was constitutional? He may have been mistaken if it turns out later in hindsight that there was not probable cause, or there was not, depending on the facts of the situation. But if he had that reasonable belief, what he did was constitutional at the time, then more than likely he's going to be found to be entitled to qualified immunity, and therefore he's not liable. And this is where a lot of the debate comes in, and there's been calls recently, well, I'm not saying recently, they're just now more in the news, where people are arguing that we need to get rid of qualified immunity, that this is preventing any sort of person that wants to assert these types of claims against police officers. This basically shields the officers from any sort of liability. Now, qualified immunity is not absolute immunity. This is something, and I venture to say, and I've read articles, really the amount of cases where officers are found to be entitled to qualified immunity is very low. Other attorneys may beg to differ with me, but in reality, it's very hard at the district court level to get a motion for summary judgment or some sort of dispositive motion, or the plaintiff's claims dismissed on the issue of qualified immunity. I know just from my personal experience, more often than not, my assertions of qualified immunity on behalf of the police officers are typically denied, and I have to take that up on appeal to have it reviewed by an appellate court, in this case, the Fifth Circuit. So, I beg to differ with people that, everybody has their opinion, but I don't see it as a qualified immunity as a carte blanche to the officers escaping liability for any sort of claims of excessive force. I don't know, Victor, do you want to chime in here?
Sure. I think
and it's a good point. It's a good point to bring in Victor, because we do end up having lawsuits filed against police officers, and it's lawyers like you, Victor, that have to look at all this and make that determination on when to file a lawsuit or why to file a lawsuit. So if you want to respond to Heather and talk us through that thought process of
Sure.
of filing a lawsuit against a police officer.
Sure. Yeah. I mean, I grew up in a law enforcement family. My father's been a law enforcement officer, my entire life, as long as I can remember. So I have a lot of respect for police officers, and the way I evaluate cases. I mean, to me, the conduct has to be egregious, right? I mean, there may be other lawyers that don't require that level of conduct, but to me, I have to be able to look at it and say, you know what, this just doesn't look right. Because ultimately, when you're talking about a reasonable officer, and we can get into all the minutia of what Mr. Rodriguez was talking about, but ultimately, if you can get to a jury, it's going to be 12 regular people looking at the conduct and deciding, right, hey, this isn't right or this is right. Um, and to me, it's got to be something because of what we have in qualified immunity. In order to get past that initial bar that Heather was talking about, to me, it has to be because the courts act like a gatekeeper, as they should, right? As they should. I don't think that qualified immunity should be abolished. I do think it has to be reworked. I think that because of the way it's held, it's done right now, you're going to have different decisions across every district court in the country. Even in our own division here in McAllen, you're going to have, it depends on which judge you get, you might get a different result. Right now, you go to the Fifth Circuit. I know Heather's saying she's not, her officers aren't getting qualified immunity at the district court level here, but I bet at the Fifth Circuit they're probably getting a better shake, right? A different shake. And so that's the problem, is such variation, right? So when we talk about abolishing qualified immunity, I'm not so sure that that's really the goal, right? I think the goal is let's codify it and let's all get on the same playing field here. So going back to how you process this and think about it, as a person that has been the son of a police officer my entire life, I understand the dangers of a police officer's job, and I think about it from that perspective, from the police officer's perspective a lot. And I have to see, what I want to see is, in my mind, just something that just shocks your conscience, right? That should not have happened. Regardless of the training or regardless of the situation, you have to look at it and think to yourself that that's just not right, right? Because ultimately a jury's going to have to look at it, and 12 regular people are going to have to look at that and think about it. So yeah, I mean, talking about qualified immunity and kind of the other training, all this discussion right now, it seems like it's geared toward, or at least we're focusing on an officer responding to some kind of force, and that's an interesting discussion, obviously, that we need to talk about. But I think, I don't mean to turn the discussion here, Judge, but a lot of what we're seeing in the recent news isn't really that, right? It's more of a situation where an officer is trying to effect an arrest. Maybe there's not any violence or any kind of resistance, but still the officer persists, and then somehow it escalates into a situation where the force is used and stuff like that. So I'm kind of curious on your thoughts about that, right? Everybody, the panel's thoughts on that, because it's easy to sit back and say, well, yeah, I mean, the police officer, he was justified in responding to an assailant or a criminal that was coming at him. Those are easy calls, right? But I don't think what we're seeing in the news, I don't think that's what we're dealing with for the most part, right? So those, when we get into what's happening recently, I think those are more nuanced, right? And maybe that's why we need this codification and some kind of uniformity when it comes to qualified immunity.
Just so people understand, when we're talking about qualified immunity, that means that the officer personally cannot be liable for damages. That meaning, if I'm suing you, police officer, I'm not going to get money from you, period. Just so we're clear, everybody that's watching understands basically what it comes down to when we're talking about qualified immunity. And I appreciate you turning the conversation, because we have started talking about the overall general concept, and yeah, it'd be great if it's just always a response. But the cases that we see in the news are difficult cases. If you don't want to chime in, if you want to stand back and not say anything about George Floyd, for example, because that's obviously something that's going to be in everybody's minds. Having an officer, we know that we use pressure points and we use different tactics to try to get compliance, but at what point is putting I'm not going to put you on the spot, Albert, if you don't want to chime in on this, but at what point is putting your knee on the neck of someone you're trying to make comply with your demands? At what point is that just a little too much and goes against the general training that an officer is getting?
Yes, sir, Judge, and that's a very good point, Judge. And obviously, I don't think you'll hear from a single police officer that will not say that officer's actions were criminal in nature. Okay, they were criminal in nature. He was totally wrong, and that's just a bad officer. And there's bad everything, right? There's bad attorneys, bad plumbers, bad carpenters, and there's definitely bad police officers, and that's just one of them. The reality of it is, when you look at statistics, officers use force. Of all the police contacts, the thousands and millions of police contacts, law enforcement officers use force only in 2% of the time. That's a very low percentage of the time, 2% of all the millions of contacts, which tells us that, 98% of the time, officers handle situations with verbal communication and officer presence. Right? It's
That 2%. I'm sorry for interrupting. That 2% is any type of force, not deadly force.
any type of force.
Okay.
And if I may chime in there, Albert, that 2%, it's when I've talked to officers, not very many of them actually have used their firearm in any sort of use of force scenario other than training. So of that 2%, it's even lower the percentage of officers, and correct me if I'm wrong, that have actually used their firearm.
That's exactly correct. And it's interesting, Judge, I've interviewed hundreds of officers that have actually had to discharge a firearm and injured somebody. And the common denominator is all of them at that point wish that would have never happened and that they would have never been there. In fact, most of them come to tears because all of a sudden they become victims. Now, that's the officers that I've interviewed. Now, obviously, you've got some officers that are bad, right? And they're going to commit criminal violations, such as the George Floyd incident, right? But the majority of the time, when you consider that police officers use force only in 2% of all millions of contacts that are made, that is a very low percentage.
That includes anything from tightening your handcuffs a little too tightly and maybe a punch, all the way to I took my gun and I shot the suspect.
Yes, sir. It could be a simple takedown, a simple arm bar, to the use of deadly force, 2%, according to FBI statistics.
And Victor, let me go back to something you said earlier about codifying qualified immunity. And I mean, you may have given it some thought. I'd never given it any thought of putting it that way and helping bring some uniformity on how it's applied on cases. How would it work if you're the legislature?
Sure.
All the legislature is on Victor's hands.
Well, that's a big ask, but I mean the problems are the obvious ones, right? Where you for instance, what Heather was talking about, the idea that the constitutional right has to be clearly established, right? So the problem with that language that we have seen in some of the community uproar, the uproar recently, is that it leads to some absurd results. For instance, even in the George Floyd case, some courts may decide that, well, you know what, it wasn't clear to that officer at that point in time, given under those very same circumstances. In other words, we don't have another case that precedes this case where an officer came to a drugstore in response to a $20 bill counterfeit and then found himself in this situation and put his knee on the neck. We don't have a similar scenario that said where a court said that was a constitutional violation, so it wasn't clearly established, right? Now that sounds like an absurd result, right? And maybe that's not going to happen with George Floyd, but there have been similar scenarios where the use of force is clearly excessive and clearly a constitutional violation, but courts have gone to the extreme to say, well, we don't have a prior case that says this, and so therefore there's no constitutional violation. And that's I think is kind of the root of this idea where, hey, this isn't right, where a plaintiff is put to that standard, right? To put to that burden. And so if we can figure out a way to have a uniform standard for measuring whether a police officer is entitled to qualified immunity, that the district courts and circuit courts across the country can apply uniformly, I think that would be better.
And Judge
Because-
Fonseca, I'm
yeah.
sorry. If I may, I want the public to know that I feel like I want to clear something up. We kind of talked about the training with Albert, and then we talked about civil liability. I don't want to forget the step that, and I'm going to use an officer involved shooting, for example. You know, that there's that one step that comes before any type of lawsuit comes to play. So, you know, now what we are seeing is an independent law enforcement agency would come in, like the Texas Rangers, to investigate the officer involved shooting. And then it's presented at some, you know, they conduct their investigation of what happened. It's then presented to a grand jury for their determination to see whether there was any criminal constitutional violation on the part, or criminal conduct on the part of the officer. And I know, Albert, I believe you've handled some of those where you've gone into and presented as far as how officers, their use of force. That's not my role. I handle the civil lawsuits and the defense of the officers in that respect. But I do want the public to understand that there is that other step where there is an inquiry into the officer's use of force from a criminal standpoint prior to it ever getting to the point of a civil lawsuit that a plaintiff may decide that they want to bring in the future.
That's a different standard, right? If you can talk about that.
Correct. I wanted to make sure that the public understands that there is that inquiry that takes place into the officer's conduct immediately after the incident.
And Judge, if I may add, Judge, yeah, I've been asked on several occasions to present to grand juries to educate them how officers are trained in specific aspects of force. I've done that on numerous occasions. And one of the things that I've been a strong proponent of is that, and I don't know if this is possible or not, Judge, but when a jury gets impaneled, a grand jury gets impaneled, I firmly believe that they need to have a course on police officer use of force with no case pending. That way, there's no allegation of, well, the person that came in presented the class to the grand jury was a police officer. So of course, and there's this case pending, so of course, he's going to side with the police officer. Therefore, if the grand jury is educated upfront with no case pending, that allegation cannot be made. And I've always been a strong proponent of that, is presenting, a class to grand juries where they can get at least some understanding on how to evaluate officers' actions in regards to the use of force.
Well, next time I impanel a jury, I'll just put on this video for them, and they can. I don't know.
Get all the
But let me bring up something that and thank you for that Victor mentioned about we rely so much on, as lawyers, we rely so much on case law, and I mean, we do it all the time. We look for cases that courts have looked at before and say, oh, look, the court already did this before. That's what the case law is for those that aren't lawyers and aren't familiar with the process, and tells the current court, do you have to do the same thing because that's what they did? So we rely so much on these type of cases. I mean, it wasn't that long ago that I was practicing. That we do that a lot. And so what happens when you have such unique circumstances in these type of cases that you don't have the case law to support them? So what do you do then?
Well, I mean, that's the problem.
Anybody?
Well, I was going to say that's the problem, right? Because, like we started out saying here, is all of these cases are so unique. And so if you have to rely on a similar case to support your position that the constitutional right was clearly established, well, then, I mean, you're already starting out kind of in a conundrum, right? And so I guess that gets back to this issue of, do we need some uniformity here? I didn't mean to interrupt you. Sorry, Heather, go ahead.
No, I was kind of laughing about what do you do? Because that's what, as lawyers, we're trained to do that. We're trained to research cases to see what is analogous to the circumstances that we have in our current case, so that we can persuade a judge to rule in our favor. And when you don't have that, I turn to people like Albert and use their expertise, and hopefully, they assist me in convincing a court that what I'm advocating for my position is correct, if there's not a case that's analogous. And maybe I'll be lucky and the court uses my fact scenario to set a new precedent, and there we go. But only to maybe next year it'll be changed again. And that's how it Victor was alluding to that. You have one set of circumstances by one court that they may find that the actions of the officer were unreasonable and he used excessive force, but then it'll go to an appellate court and they'll overturn that lower court's decision. And even within the appellate courts, I mean, there's difference of opinion, and the circuits are split. So we turn to the Supreme Court for guidance and to see which way they are going to go. And I don't know if the answer is codifying it. Maybe that is one way to give some sort of guidance, or we need to wait for the Supreme Court to refine the parameters of how we're going to look at these cases in the future.
So then when you are presented with a case where you don't have precedent, you don't have case law to support a position, and you do bring in someone like Albert Rodriguez to kind of educate the court when it's a dispositive motion. At that point, if playing devil's advocate here, Mr. Rodriguez, aren't you Monday night quarterbacking at that point?
Yes, sir, but I always analyze the officer's actions based on an on-scene police officer. So I look at their report and I place myself or a reasonable police officer in issues and ask, what could a reasonable officer do when presented with the same or similar circumstances, pursuant to law enforcement training? So I actually put myself or another police officer in issues. So that's the objective viewpoint rather than subjective. Rather than saying, this is what I would do, I go, what could a reasonable officer do when presented with those particular circumstances? So yes, I look at it from that standpoint, but I consider also the fact that officers have to make split-second decisions in those dangerous type of situations.
And if I could push back a little bit on the qualified immunity needing some tweaking, isn't the fact that the judge gets to make a decision, acts as the gatekeeper, doesn't that kind of help then in making sure that if someone's asserting qualified immunity, that it's an actual valid point to make? Because without the judge, then you can't get there. The jury is not going to hear from someone like Albert. And by that point, by the time it gets to a jury, you've had briefs and you've had depositions and you've had an opportunity, both sides have had an opportunity to look at both experts and what they're going to say. And the judge gets to, as you mentioned, Victor, is the gatekeeper. So isn't that where there's a safeguard in the way that we're applying qualified immunity? Or not that we have to.
Sure, but the statute itself is going to be what the judge is going to use as a tool to be the gatekeeper. We won't remove the judge as a gatekeeper. The judge will apply the law as set out by Congress, right? So the judge will still be the gatekeeper. I mean, we have similar, statutory gatekeeping functions all throughout the law, right? I mean, in the Texas Tort Claims Act case, you have to send your notice. If you don't send your notice, you don't have a case, right? It's similar type stuff. So ultimately, the judge would still be the gatekeeper by applying, hopefully a uniform law that all courts are using across the country, as opposed to having, varying degrees of results, throughout, even within the same division in a district court, for instance, in McAllen or Houston or, throughout the Fifth Circuit. So.
And I'll ask you, Heather, on the flip side, because the judge is the gatekeeper and judges have different judicial philosophies and you can have a judge in Brownsville and a judge in Houston be presented with the exact same facts, and they can both reach a very different conclusion.
Yes, that happens a lot. That happens a lot. And we, that's the functionality of how, the judges and how they rule and how they view the facts and how they view the law and how they apply the facts to that law that they have. And, they use precedent, they use case law that, what has happened in a similar case before. But again, going back to the scenario, if you don't have a case on point, the judge is there to filter in and act as the gatekeeper of how the jury will view the facts as presented by both sides. Now, I will say though, when we are presenting the defense of qualified immunity, we will educate the jury and have jury instructions to inform the jurors that, you're not looking at this just Monday morning quarterbacking like we're talking about. And we're using that phrase because that's what we see. And we see these videos that the news puts out on the media and all the commentary that comes after. We're looking at it in hindsight of they shouldn't have done that. They could have done that better. They could have handled that situation better. But as Albert points out, that's not the standard that how we view the officer's actions when we're looking at these types of cases is what was the law enforcement officer, what was going through his mind at that point in time that the actual situation was taking place. And we look at it from the perspective of a reasonable law enforcement officer, not just me looking at it at the video and saying, hey, you know what, they should have done that better, or they could have handled that better. We can say that about everything.
Right. Just watching the news and like, okay, this is what could have been done, or I could have done something different, because we're not police officers and we don't know all the facts and can't make a decision. And let me just jump in here in between this whole discussion about judges being as the gatekeepers. And I just want to highlight that for people that are watching right now. That's why it's important to have a judge that understands what's going on and that is capable to understand these concepts and is able to apply the facts of the law to the facts that are presented. So it's very important who your judge is. I think everybody can agree with that.
To follow on that, we as lawyers, and I think Victor will agree, we appreciate when the judges take the time to really dissect what's going on a case. And of course, if they are educated in that area of the law, especially this area of the law that's so unique, I'd say there's only a handful of attorneys that practice these types of cases, and they're very difficult. They're very complex. Constitutional law is very complex, and there's so much. They're very fact intensive, and as Victor knows, they're difficult cases to not only to bring but also to defend as well. So we're very appreciative if when there is a judge that is educated on these types of issues and on any legal issue for that matter, because it makes our job not easier, but we're advocating for our clients, our respective clients, and at least we feel that there's a fair handle on the case.
And Judge, if I
Yes,
may, add to
Go
what
ahead.
I was saying, is that a couple of things she mentioned earlier about that in hindsight, officers could have done definitely something different. Every situation that I have evaluated throughout my career, 40 plus years, right? In hindsight, the officer could have done something better, right? In hindsight. But at the time, right, making those split-second decisions, that's what he actually did. Whatever he did, that's what he did. So in hindsight, someone can always do something better. And that's always the case. Now, when Heather was talking about media and what's presented in the media, the majority of the time, the totality of the circumstances are not presented. Only a few circumstances are presented. And that's what, when we prepare reports, right? We present the totality of the circumstances. That way it's properly evaluated from what the officer knew and perceived at the time, and not just from one or 2 points of what actually occurred.
Victor, you were going to jump
Sure.
in?
Yeah. No, I was just gonna. I'll just talk about Monday morning quarterbacking, and I understand the concept here. And like I said, policing is a very dangerous profession, and I agree that the police officers deserve a lot of deference because what their job is very dangerous, and it does require decisions to be made in very stressful situations. But the courts, that's what we do, right? As lawyers and as judges and as juries, that's our job, right? To Monday morning quarterback. I mean, that's why we're here. And if we're not Monday morning quarterbacking, then, who's going to hold the police officers accountable? There's got to be some accountability, right? Heather was talking about the intermediary level, maybe the Rangers doing an investigation. But what I have seen is that very, very rarely do the Rangers recommend prosecution or any kind of disciplinary action toward police officers. And as a cynic and as a citizen, you can you can just think of the reasons why people might be skeptical of that, right? And so, as much as we want to say, well, you shouldn't. Your hindsight's always 20/20 and all that stuff. Well, that's what this system is for, and that's what the court system is for, and it's necessary, and so we can't get rid of it. And police departments and police officers have to be held accountable, and that's what the courts are here for, and the juries are here for. We talk about objectively reasonable officers and totality of the circumstances. Sometimes the totality of the circumstances circle gets too wide, right? Way too wide. Well, that guy, he was super violent yesterday. He was beating up his wife. You encounter him the next day. Do the totality of the circumstances include the fact that he was beating up his wife yesterday? Because the police officer that man was beating up his wife yesterday. He might be violent today. I can use force. So when you talk about totality of the circumstances, you have to be specific, right? And that's our job as lawyers and judges, to determine the scope of what's going to be presented to a jury, and a jury is going to make those determinations, right?
Yeah, and that's a great point to make, because how we define these terms, these legal terms, it varies on a case-by-case basis, and that's where Victor and Heather fight it out in court on, well, the fact that this person was crazy yesterday doesn't mean that he's crazy today, or that that there was a tendency of him doing X yesterday or a week ago. I had cases where the police officer says, "Oh, he's a habitual X drinker, drug user. I've encountered him a dozen times," and but then you can use that against them and say, "Well, he never tried to do anything to you, right?" And you go back and forth, and that's where the fun comes in for us as lawyers. I think I look back at those type of cases and those scenarios where you really have to parse everything, and we can go on and on and on. But I do want to have some time for questions. If anybody has any questions on Facebook Live or YouTube, Mari, do you have any? Has anybody asked any questions?
There is one question, Judge. One question was being asked by Mr. Castellanos. Many states are looking to remove the ability of police officers to use force when detaining individuals. What benefit, if any, does this provide to law enforcement?
So some states want to just get rid of the possibility of using force. Period. Mr. Rodriguez.
Yes, so it is trying to get rid of the use of force to detain individuals, correct? Is that the question?
I believe so.
Yes. Well, then
Correct.
Obviously, officers use detentions for investigative purposes when they have reasonable suspicion. You can detain somebody when you have reasonable suspicion, right? And obviously, if you are not allowed to physically stop somebody when they don't comply with verbal commands to stop and that they're being legally detained, then they're just going to be allowed to run loose, if you will. There's nothing that we can do beyond that if force cannot be used to detain the individual. So he's free to go.
Yeah, I mean, what do we want? Just not have an officer be able to stop someone from committing a crime if it's something's happening in front of them?
I think that would be difficult to achieve. I mean, the effect of the police presence. You know, I don't know if there would be an effect if they are presented with a situation where somebody's resisting or evading. I mean, at that point, they just go. Does the suspect just leave and they don't affect any sort of investigatory stop? Now, I haven't heard that, but I have heard of where some state, you know, the governors are banning some types of uses of force, like chokeholds. And I think of what, I'm not sure if it was Michigan or California, but those things, certain types of force, I've seen in more recent news where they are banning things like that. And I don't know if Albert, you can comment more on that.
Yes, definitely. Most of the agencies that I know in Texas and the ones that I've dealt with out of Texas have banned the use of chokeholds. And chokeholds basically is when an individual controls the air that's putting pressure on the trachea. That's a chokehold. They've banned that for years and years. The other type of neck restraint is called a lateral vascular neck restraint. And that is actually putting pressure on the carotid arteries on the side of our neck that slows down oxygenated blood to the brain, that causes the individual to pass out, go unconscious. In most instances, they do return to consciousness. And in some instances, they die, right? Most agencies have also allowed the lateral vascular neck restraints, controlling oxygen or oxygenated blood. That I know of most Texas agencies, that's done away with. The other thing that officers are highly trained on also, Judge, is to avoid the allegations of positional asphyxia. That being meaning that when an individual's in a prone position, right, to try to get him cuffed as soon as possible, then sit him up or put him on his side as quickly as possible to avoid any type of compression on the respiratory system, to avoid the issue of positional asphyxia. So those things have been addressed for many, many years. Like, for example, the George Floyd incident. Just the position that he was in was compromising, probably, I would speculate, was compromising his respiratory system. So those are the kinds of things that officers are trained, and Texas officers are highly trained in that particular area. And most agencies do ban those particular tactics.
Victor, you want to comment?
I guess getting back to the original question, right, about the use of force for certain stops, and I guess this kind of evolved into another discussion, but I agree that you know, police officers need to be able to use force. I think the question is, you know, to what extent under the circumstances, right? I mean, if you have somebody that's a potential witness or a potential suspect or somebody on the street that's not doing anything that's obviously illegal, not committing a crime in front of an officer, that just wishes not to talk to the officer for whatever reason, isn't under arrest, you know, if he wants to leave, should the officer be able to grab that person and then perhaps cause a physical response by that person and then leading into some kind of use of force that turns deadly? Should the officer be able to do that? I don't think so, right? I mean, I think the circumstances have to justify the decision by the officer to engage somebody when, you know, when that engagement is going to logically lead to some use of force, right? If you've got somebody that, you know, a teenager that stole some bubble gum or whatever, cigarettes, should the officer, engage that person knowing, in a way where it's going to invite the physical altercation. I think that we need, that those situations should be looked at. And you can get into all kinds of, should you chase a fleeing suspect if they just ran a stop sign, if there's no other, indication that that individual is a violent person, if he just, ran a stop sign or a stoplight, and, should you engage in a high speed pursuit? Those kinds of questions come to mind. And I do think that we need to kind of relook at that. And I know there's already guidelines and guidance, but it seems like, you get a case every once in a while where, where it starts with a mundane, run of the mill kind of situation that turns into a deadly scenario when it really shouldn't have, right?
And I think the George Floyd incident is a prime example that he was somebody at the store said that he may have stolen something.
$20 counterfeit,
A forged, was it?
Okay. So yeah, and it really did escalate, and that's where I guess I'm getting my constitutional review standards mixed up, or that's where like a strict scrutiny type of deal comes in, and or then you have the totality of circumstances approach in looking at this case. So, Mari, any other interesting question out there?
We have one more question, and this is from Mr. Aleman. His question is, if we defund the police or do away with the police, do you see that the crime will rise or decrease?
Well,
So, I mean, if I want to, I think that the notion behind defunding the police or doing away with the police, and I want to say I look at New Jersey because I think they took an approach where they got rid of most of their police force, and I can't remember the town in New Jersey, but they essentially had the police officers all reapply. And they put more strict standards and a huge emphasis on training and really screening the police officers. And they had a turnaround on not only the morale of the police department, but the effectiveness of the police department. That's one approach that I've read. The other of defunding the police, I think, comes from the idea of we'll put more money into communities. We build up our communities where we have more focus on and more resources for mental health, people that need assistance with mental health, more community educating our youth, community policing, where we're out there, trying to build up the communities to in the big picture lower the crime rate. That takes a long time, and I don't know if it's a good idea, and I think we should be doing that anyway, but I don't think we need to defund the police per se, but I do think we do need to focus more on our communities.
We're taking a little, gone away from legal aspect to a more policy type deal. Not that I mind, but I mean, I'll let you, if you guys want to comment, Albert.
Yeah, well, and again, in speculation, I would say that obviously if you do away with police, the crime rate would increase because bad guys are going to be bad guys, right? And who's going to, put those bad guys in control? When someone breaks into your house in the middle of the night, who do you call? Right? When the situation is extremely dangerous, midnight, 2 o'clock in the morning, someone's breaking in, who do you call? Right, and those are the things that we can expect to see if that ever does happen.
Victor?
Yeah, so one aspect that we didn't talk about today that I think kind of ties into this is, the idea about individuals with mental health issues, right? Because a lot of times, a lot of these calls that end up bad, that there is some mental health aspect underlying, right? And we've seen a couple of cases. Heather and I have worked on a couple of cases where, you know, without making any concessions or any admissions here, had there been a little bit better training with regard to mental health, you know, maybe the scenario would have worked its way out differently. And so I think part of that defund, when I hear that, I'm not thinking, you know, abolish. I don't think anybody wants to abolish the police. You know, maybe the better way to look and think about it is, you know, rethink how we address certain situations, rethink how we apportion certain resources. Because I do think the mental health aspect really needs to be considered at length. You know, should you send a social worker to a situation instead of a police officer? I don't think so. I don't think that's the right answer. But you know, should you have somebody that is trained, specially trained with a mentally with a mental health in the mental health field, either assist an officer in certain situations or help train officers with regard to certain situations? Yeah, I think that's the right idea. And I like I said, I'm not asking to send social workers to dangerous situations, but I do think that needs to be something we look at.
You're kind of giving a preview of one of the topics in this series. In a couple of weeks, maybe in a couple of weeks or in a month, we'll be talking about mental health and the justice system, because it's a problem, and I think we can do a lot better in managing, in dealing with it and addressing it early on, and preventing a lot of what happens once people start committing crimes, and once they get into the system and whatnot. It's a big problem. And I think, but going back to the defunding the police, yeah, I don't think getting rid of police it's not the answer. And we can't really build a community without police. We can't say, okay, fine, we're going to invest in education or in healthcare and jobs and whatnot, which we should do, but not have police at the same time, because unfortunately there is always going to be a fraction of society that is going to be committing crime. It's just a reality. It's just how do we deter crime? How do we deter people from not doing what they should as citizens in our community? So, and I think the city that you mentioned, Heather, I think that was Camden, New Jersey.
Yeah, you're right.
And I read about that, and I think it was a very good approach. Their problem was that police officers in that particular department had pretty much been bought out by the drug lords in the city, and the crime had increased exponentially. So they fired everybody. They didn't defund, they fired everybody, and then they implemented strict hiring practices that allowed the city of Camden to hire qualified, good cops, because that's what we need. We don't need to get rid of them. We just need to make sure we have good cops, and obviously the training that they receive is very important. And I've had the pleasure of working with several police departments in Hidalgo County, and I know that they are well trained, that they're an asset to our community, and that they mean very well. And you know, there are circumstances in which sometimes someone's constitutional rights need to be upheld or addressed in court, and that's where Victor comes in. And there's nothing wrong with that. It's just we have the access to the courts. That's what the courts are for, and that's why you have judges to see what gets through and what doesn't. And I think our system, insofar as this topic is concerned on use of force, gives us tools as judges to be able to do a good job in addressing any concerns anybody may have about police conduct and their use of force and how they move forward against that particular officer. So thank you all. It's already past a bit past the hour. I appreciate all three of you for being here. A great discussion. I can keep talking over and over. This is something I'm very passionate about. When I mentioned that when I worked for the Justice Department, that was before I even went to law school, that I did this kind of work. And I kept doing it, as Heather knows, when I was in private practice. And I like the fact that during my campaign, I've gotten to know a lot more police officers, and that I've been exposed to a lot more on the bench. So thank you all for being here, and thank you for those who asked those questions, very good questions. Even if you took us out into the policy area, it went to a very interesting discussion, and I'm sure it's not going to go away. We're going to keep having this discussion for quite a while, because it's an unfortunate consequence of what's happened in other parts of the country that are going to affect our community. And we should be ready to discuss those and take those, ask those difficult questions and be able to provide responses. So again, thank you all for being here. And thank you everybody who watched live on Facebook and on YouTube. Stay tuned for the next theme. We'll be back in the open forum series in 2 weeks. Thank you all. Have a good night.
It was good to see y'all. Take care.
Bye.
Bye-bye.